All right, we've got Commonwealth against Erica Lawson, 23 CR 399. Is that your client in Bourbon County on Zoom, Mr. Colson?
It is, Your Honor.
All right, gentlemen, we're here for a pretrial conference. And where are we today, gentlemen?
Your Honor, the Commonwealth and the defense continue to discuss this case. The Commonwealth has recently provided a large amount of discovery in order to ensure that that discovery compliance is had. I believe that we will ask the court to enter an order that the parties have put together regarding this matter. And I believe the
Let me interrupt you for a minute, Mr. Colson. You all mediated this case back in December? Or
we had a mediation with the prior Commonwealth attorney. We were not able to resolve it.
Okay. Mediation was unsuccessful.
Yes, although we have left the option open for a second mediation, Your Honor.
Hey, where's that little list at?
We're getting a lot of noise from, we had this happen before, Mr. Colson.
Yes, sir.
We get a lot of noise from Bourbon County Jail.
Yes, sir.
Bourbon County, would you all mute, please?
Yes, sir.
Thank you, Bourbon County. All right. Sometimes that happens.
It's fine, Your Honor. I don't expect a need for Ms. Lawson to speak at this hearing.
Okay. So the mediation was unsuccessful. And I understand, where are we on discovery? If you this court heard several arguments about discovery in the past. Does the defense feel like it is getting all the discovery it's entitled to?
We do, Your Honor. The Commonwealth recently provided whole file discovery to us electronically to ensure that their constitutional duties are met. We feel confident in the Commonwealth's assurances that that has been provided to us. We do believe that there are still electronic devices that are undergoing forensic evaluation. But obviously, until those reports are created, the Commonwealth is under no obligation to provide that to us. We had previously filed 2703D motions for common carrier disclosure. However, again, those devices are undergoing forensic evaluation. And so at this time, we do not believe that the Commonwealth is under any current duty to provide anything until that is completed.
Okay. Okay, so the court's been tendered an agreed order removing the death notice.
That's correct, Your Honor.
And would you tell me about that?
Your Honor, at the outset of this litigation, prior to the return of the indictment in this case, we filed a motion for a bill of particulars. This follows the initial charging of Erica with second-degree manslaughter rather than murder. Your Honor, there has never been any allegation or evidence that Erica inflicted this injury, nor has there ever been any allegation or evidence to support an intentional killing as it regards Erica Lawson. The recently adopted aggravator found in 532.025 that was adopted in 2023 by the Kentucky legislature makes death eligible the intentional killing of a child under 12. And that goes beyond not only the intentional murder statute, but as it would relate to intentional conduct, but it requires the killing to be intentional. There has never been any evidence that could support either an intentional murder conviction nor has there ever been any evidence that the killing of this child was intentional as it relates to Erica Lawson. This follows 1.5 years of discovery review, and that includes medical examiner reports, DNA reports, electronic analysis, and just generally a huge investigation that called in both state and federal partners in this case. So as we litigated this case, we asked the court to enter a order requiring the prior Commonwealth attorney to tender a bill of particulars as it related to the mens rea of intentionality. In the response to that motion for bill of particulars, the prior Commonwealth attorney doubled down on the idea that a delay in rendered aid could rise to the level of intentionality. That theory is unsupported by the clearly established law from the Kentucky Supreme Court, which we have included in the agreed order that has been presented to the court today. Succinctly, Your Honor, the Commonwealth is unable to prove intentionality as it relates to Erica Lawson. It has never been able to do so. There has never been any evidence which would support a finding that she intended this outcome, nor has there been sufficient evidence to suggest that this child was sexually abused. I will leave out the gory details because they're troubling. However, even the state's own medical examiner comes to no conclusion regarding that. Given that the Commonwealth is wholly unable to proceed under a theory of intentionality, and because we believe either prior to trial or at trial, a court or a jury would not be able to enter that finding, the parties have agreed to go forward under a murder prosecution against Erica under a theory of one murder. This doesn't mean that Erica will not be tried for murder or cannot be tried for murder. It simply finds under 507020 sub B that the theory of culpability will be circumstances manifesting extreme indifference to the value of human life. Because based on that statute and the legislative history, the Commonwealth cannot prove that, the parties have agreed to go forward in a non-capital murder prosecution.
A murder prosecution without the death penalty as an option.
That's correct. Ms. Lawson still faces life in prison, Your Honor.
So, Mr. Taylor, we've heard from defense counsel. He's made some statements. What's the Commonwealth's position on those statements? It's been 1.5 years. What can the Commonwealth report as far as evidence with regard to Ms. Lawson and this case?
Judge, we've carefully reviewed all of the evidence, of which there is quite a bit in this file, with the specific look at the level of intent. And as we know, as lawyers, there is the highest level of intent is, of course, intentional, knowing, wanton, reckless. And the statute tells us where we are with regard to homicide based upon that level of intent. For the death penalty case to go forward, for a jury to be instructed, intentionality has to be proven. After several attempts to get a response as to intentionality, and we've looked at all of the same, there was a very curious response in that one acts intentionally when his conscious objective is to cause a result or engage in that conduct. And then talks about wanton behavior, goes back to intentional. Defendant is charged with the intentional killing of her daughter, E.H. As to intentionality, the Commonwealth states that the defendant acted intentional. The defendant acted intentionally.
Are you quoting the prior Commonwealth Bill of Particulars response there?
Yeah.
Is that okay?
By saying she acted intentional by acting intentionally. that is not an answer to how did this person act intentionally wrong. And there is nothing, and I assure you, as an officer of this court, there is nothing in the documentation that we have and that we have provided defense that indicates intentionality. There is plenty of evidence that indicates wanton behavior. This is a case, in our opinion, of inexcusable neglect. This is a child that was somehow injured. We don't know exactly how, but we do know what the injury was and what kind of rough time period we had. Somewhere between 48 and 72 hours is about as close as we can get from the time of the injury to the time of the child's death. Now, myself, Your Honor, other folks in the same situation, I suspect wouldn't wait 48 minutes to have their child looked at under similar circumstances. That's why it is our professional opinion that this is a case of wanton murder and will be prosecuted as such.
We adopted legal justification from the Commonwealth, Your Honor. I want to make very clear. This case has been subject to more rumor than any other case that I've been involved with. Those rumors are not supported by the evidence. Mr. Taylor and I have ethical obligations to not go out there in public and review or reveal all sorts of evidence. But I want to make very clear that these allegations well, there are many false things out in the public that simply are not supported by the evidence. And while we have an ethical obligation not to go out and crow about those things, we believe that at a trial of this matter, the public will be able to see what the actual evidence is in this case.
All right. Mr. Taylor, anything else?
So,
You've signed this agreed order. You agree with all the findings set forth in the agreed order.
and Judge, I would also say this investigation is not complete. There may be other people charged. Once the evidence is fully, once we have all the evidence in this case, there may be other individuals charged. All that we are doing today is seeking to amend the indictment that reflects the evidence as it is. And as it is, it does not support. And I believe I'm ethically compelled to present this case with the evidence that we have that supports wanton murder. It does not support an intentional murder that would justify the imposition of the death penalty. And that's all we're doing.
All right. Anything else, counsel?
No, Your Honor.
No, sir.
All right, the court having reviewed the agreed order and the Commonwealth and defense stipulating that there's no evidence that the defendant inflicted the injury. There's no evidence. Commonwealth will not be able to prove intentional killing by the defendant, Erica Lawson, and that defendant's role in this is a failure to provide care, for lack of a better word, which would justify a murder charge, but not a death penalty notice. Does the court surmise that fairly?
Your Honor, that will be the Commonwealth's theory. And of course, the Commonwealth will vigorously prosecute this. We will vigorously defend this. There is evidence. The parties will continue to work through this, but with all facts drawn in the favor of the Commonwealth, their theory of trial must be a one murder theory.
All right, the court will enter this agreed order. What next for this case, gentlemen? I gather it's too soon to start talking about a trial date, or do we start talking about a trial date?
If we start talking about a trial date, Your Honor, the Commonwealth would say that there's still evidence out there that's being pursued. I think the late fall of the year would be the earliest we would be prepared to try this case. I think it's helpful to get us moving. This case has sat for some time. A trial date with maybe a status conference and pretrial would be helpful. We're not opposed to mediation. We want to get it moving.
How many days to try this case?
On a non-capital, I would say probably 6 days. A capital trial would have taken about a month. I think that non-capital, we can do this in 6 or 7.
Well,
Judge,
based on what you all are saying, the court's not satisfied that we're ready for a trial date yet. I'm going to give you one more pretrial conference. And at the next pretrial conference, in between now and the next pretrial conference, I would like counsel to work together and complete whatever investigation needs to be completed and exchange whatever discovery may come up, with the idea that we'll get a trial date at our next pretrial conference. That's what, to me, what I'm hearing. It's just not ready for a trial date yet. May 5th at 9?
I think that's too early, Judge.
Okay,
I think at the very least late summer.
for a pretrial conference.
Yes, sir.
All right,
We've still got evidence that hasn't been developed that, other than to just come back and tell you we're not ready.
okay,
I don't know that it benefits.
all right. So be it.
I hate to be rude, I'll be out the month of July. Would it be okay if we looked at August? It would be okay with you.
We can make it work.
August 4th. Is that a Monday, or do you want 9 or 1:30?
We could do 9.
All right,
Is that a motion, Dave, Judge?
regular motion day.
Thank you, Your Honor.
Anything else?
Sir.
Not this time, Your Honor.
All right, thank you all.
Thanks, Judge.
Ms. Lawson, that's all for you today.
Speak, just send a message real quick to Ms. Lawson.
Sure.
Erica, will you call me in about an hour?